Hey, my name is Nick, and I'm going to give you some tips that I think will help you if you have a pending small claims case coming up. So you will maximize the few minutes you have in front of the judge, the commissioner, the pro tem to fully put all of the odds in your favor and almost give yourself an unfair advantage within the limits of the law. In small claims, and this applies to California only, you're not allowed to use an attorney during the trial. However, you can use one to prepare for the trial. You can have an attorney prepare your trial brief. You can have an attorney coach you. And it's a very, very important idea to at least do one kind of role play with someone that is knowledgeable, that is impartial, that can see the other side. You don't want to practice for your hearing with someone who's only going to take your side. You want that jerk who's always playing devil's advocate. That's the person you want to practice your arguments with. So let me give you some tips, starting with, do you have a valid case? So in small claims, it's not what you say, it's what you prove. There's too many people that go in there thinking that they're just going to tell a really compelling story, but they don't substantiate their arguments. Now, why is that a problem? Well, first, the plaintiff has the burden in small claims court. And what is the burden? The burden is by the preponderance of the evidence. This doesn't mean it has to be beyond a reasonable doubt. That's not for civil trials. What this means is that you have to convince the judge, and it should be obvious, it's only the judge, there's no jury for small claims, that all things being equal, you prevailed by just a small amount, a small margin at least. And that's why it's so important to not just prepare and rehearse your arguments, but to bring those exhibits, the proof that substantiates what you're saying. That will help you overcome that threshold and eke out a win, even if it is extremely close, because the defendant will win basically by default if the plaintiff doesn't satisfy the burden. So there are small claims hearings where the defendant doesn't even need to present an argument because the plaintiff has failed to meet their burden. So if the plaintiff claims the defendant owes them, say, $1,000 because the plaintiff loaned the defendant $1,000, and the defendant said, no, I didn't receive any money from the plaintiff. Well, it's up to the judge to decide whether the plaintiff is more credible or the defendant is more credible. And if it's just one side presenting their oral argument in comparison to the other side presenting theirs, neither side has the preponderance of the evidence. Neither side has a preponderance of the credibility. It's not going to suffice when you say, I've been doing this for 20 years. I am a very honest person, Your Honor. I would not be here if it wasn't true. I wouldn't take the time to come down here and pay. None of that works. What works is, here's a text message where I said, okay, you agree that you're going to pay me back this $1,000 by December 31st, 2023. And they respond in some form of unequivocal acknowledgement. Yes, or okay, agreed. If they don't, then that's your red flag early on. Now, as I talked about, the preponderance of the evidence is very slight. It's just more convincing than the other's burden. It's more convincing than the other's argument. So if it's basically both sides are almost equal, but it's probably that the plaintiff has maybe 50.0001% more credibility, believability, who's going to win? The plaintiff, even, and it's almost that tight, that close. And that, again, I think I need to underscore this because a lot of people don't recognize that if it's exactly similar, there's no way to tell. This happens a lot in car accidents where you claim the defendant hit your car, the defendant claimed you hit their car. This happens in intersections, this happens on highways, on freeways. And since nobody ever seems to have a dash cam for no good reason, then it's just the plaintiff's argument that the defendant hit me, and they have no way to prove it because they show damage. That's not proof of causation. If you have a witness, a police report, even though it's arguable whether police reports are admissible, if you have a police report where the officer uses their professional discretion, that's a neutral, supposedly neutral third party that can help the plaintiff eke out a win. And similarly, if you're the defendant and you have that police report showing that it was the plaintiff's fault, then you're going to prevail if the plaintiff can't rebut that with similar or better evidence. So the problems with verbal contracts, which so many people rely on, just a verbal promise, are that they're not worth the paper they're written on. Now, that's kind of a joke because a verbal contract is not written on paper. That's why they're borderline useless. Yes, they are enforceable. Yes, there's even a statute of limitations for them. But the problem is, how do you prove what was agreed upon when you don't have any kind of physical or electronic writing? So the statute of limitations is also lower for verbal contracts as an additional reason not to use verbal contracts. So here's this chart that I put together, and you can see the different statute of limitations for very common civil actions. So for 1 year, you would have 1 year to bring a legal malpractice claim from the date of discovery. There's another statute of limitations depending on the actual date of malpractice, but focus right now, just 1 year from the date of discovery of the legal malpractice. And then medical malpractice, again, 1 year from the date of discovery. You still have another recourse, but I'm giving you the difference here. And then defamation, date of publication. I'm going to not identify all these because you can read. I'll put this on the screen, obviously. But for something like breach of contract, you have 4 years to bring a claim for breach of contract if it's written. And if it's oral, then you have half, only 2 years. And that goes to the date of breach. What about debt collection? Well, if you have something that is not in writing, that's just an oral agreement to pay, 2 years. But if it's in writing, 4 years. So that's why, in addition to avoiding the ambiguity, the mutual misunderstandings that happen with verbal contracts, a written contract is extremely important. And as this presentation is based on, helps you prove your argument. So don't go into court with a really good argument and really lacking evidence. What you want to do is have your evidence make your argument. And there's a couple ways that you can do this even better. So the judge will have access to your exhibits. That's why you need to submit them at least 10 days prior so you can get confirmation from the court that they've received it through the electronic submission. You also need to make sure the other side has seen them. Otherwise, the judge may not make it admissible. And this is also where you would want to submit your photographs, even videos, so the judge can pull it up, hopefully look at it before the trial begins in their chamber. Also, you want to make it as easy as possible for the judge to find the relevant exhibit and then the relevant parts of that exhibit. So what you can do is make a trial binder, doesn't have to be formal, have all of your exhibits lettered, A, B, C, D, E, F, G, and then have the table of contents with each of the exhibits, A, B, C, D, E, F, G, which explains what each exhibit is. So the judge can refer to the table of contents and identify where each exhibit is. This happens a lot in landlord-tenant cases. The judge would want to see the lease agreement. The judge would want to see photographs of the damage. This happens a lot with security deposits, especially. The judge would want to see the itemization of the security deposit disposition. That's where the table of contents will absolutely help the judge help find in your favor. And then within each exhibit, then number the pages. And then within the exhibit, furthermore, highlight exactly what was said if it's in dispute, that the defendant agreed to this. So the judge now knows which exhibit it is based on the table of contents in the letter. The judge knows which page it's on because within each exhibit, you've numbered the pages. And then you can tell the judge, Your Honor, and always refer to the judge as Your Honor, regardless of if they're a judge or a pro tem. Always Your Honor. They like that. And don't answer questions more than as succinctly and directly as possible. Many of the questions the judge will ask are phrased as a yes or no. And it's so difficult for people to just answer in the affirmative or negative without giving a narrative summary answer or more than just summary. It's not helping you to bury your most salient facts under a pile of nonsense. Basically, you want to lead with the most compelling argument, knowing that if the judge needs elaboration, which they usually don't, they will ask for it. The judge didn't ask you to tell the judge how long you've been in business, where you met the defendant. None of that helps you unless the judge finds that to be material in which the judge will ask you. So don't try to anticipate what the judge is asking. Just answer the question as succinctly and directly as possible and lead the judge to the exhibit that does the talking for you. That's why you want to have receipts. You want to have proof of payment. If you loaned somebody the money, you need proof. If you didn't have a written agreement, you can still find something in form of a text message, a PayPal sending, Venmo, Zelle. But that's why whenever you pay somebody, you want to write in the memo. It only takes about 15 seconds and it can save you many hours over many days of trying to rehash the conversation and look up everything. If you just spend a little bit of time as you go preparing for trial, knowing that in life, things usually work out, but when they don't, it's usually because you didn't expect it. Start to think like a lawyer. Start to think when you're doing any kind of business transaction, if this goes sour and if the other side actually is not telling me the truth, they're not giving me the whole aspect of the story, or they're just BSing me and they don't plan on performing, what would I do to prove that I was right? And you start to get in that mindset, you'll start to take precautions early on, which are always easier. And not just easier, but can help you prevail when you otherwise wouldn't. So I hope you found this presentation useful on some big tips for small claims. If you'd like to see more, then let me know and I will make more of these. I thank you for your time and I hope it was